Good morning. I'm David Horgan with Relativity, and I want to thank you for being here bright and early on the morning after whatever you may or may not have been doing. What happens at Relativity Fest stays at Relativity Fest. I'm really pleased to welcome three very distinguished lawyers in the field of e-discovery. It's a group that covers some vast experience in different areas. And the reason we've brought them here today is to give some expert analysis of some of the data that we collected with Harris Poll. Because last year we were sitting around in the Relativity offices and we're discussing that, intuitively we know these things. We know people do things on their email they shouldn't. We know people do things on wireless that they shouldn't. But we didn't have any really good data on it. So we commissioned Harris Poll, which is a subsidiary of Nielsen, to conduct a study on employees and their data habits in the workplace. It was a rigidly scientific survey conducted by Harris Poll standards, and we worked with them closely in formulating the questions to try to get an accurate gauge of just how much of the wild, wild west it really is out there in the world of what employees are doing with their data. So when we sat down and tried to think of, let's have some experts to discuss this, we thought, who better to do it than an employment lawyer, someone who consults business organizations on what they should be doing in the field of e-discovery, and then someone who's involved with a company that has lots and lots of data. That gentleman is on the end. It's David Kilgore. He is corporate counsel with Rackspace. As you know, Rackspace is very active in the field of technology. Based in San Antonio, Texas, David's a graduate of the St. Mary's University School of Law in San Antonio. He brings what I have always considered the ideal resume for someone in the field of e-discovery. Not only is he a lawyer, but for about 20 years, he was the director of IT for the Rice University Business School. So he's what I would call the quintessential techno-lawyer. Please join me in welcoming David Kilgore. Naloy Ray does something that probably 10 years ago not many lawyers did, and certainly 20 years it was almost unheard of. He is part of an e-discovery practice in a law firm, not just any law firm, but Littler Mendelson. And I think it's fair to say that Littler is probably the biggest employment law firm in the country.
Quite so.
So Naloy's experience is he's e-discovery counsel with Littler. And he is someone, obviously, who knows this profession and this industry inside and out. With his employment experience, I think he's going to have a great perspective on what these employees are doing, and of course, as the title of this session says, what kind of risk that creates for their employers. Please join me in welcoming Naloy Ray. And then finally, a guy who probably needs no introduction. George Sosha is the co-founder of EDRM. He's an attorney with years of experience in e-discovery. He's now with BDO, where he advises corporate clients on e-discovery and information governance and related matters. George has been a feature on the e-discovery speaker circuit for many years. And as George and BDO advise companies, we thought, who better to talk about what employees and their employers should be watching out for in the world of employee data. Please join me in welcoming George Sosha. And so how we're going to handle this is I'm going to go over the results of the poll with you. And after I set the stage by giving some of these numbers to you, I'm going to consult our three experts. We're going to start off with Naloy with the employment lawyer's perspective. We're going to move to George with the corporate consultant lawyer's perspective. And then we'll get David involved here with the data lawyer's perspective. As I mentioned to you, we did the survey with Harris Poll. It was conducted from late December to late January of this year. The sample was approximately, it was almost 2,000 people generally surveyed. I think when the final numbers were crunched, it was closer to 1,500. They included only people who were full-time in a traditional office setting. And I'm going to ask our experts here whether they think we made a mistake on that. We actually made that call in conjunction with Harris Poll because the decision was made that if you want to see how it's really going to create risk for employers, a traditional office setting with the traditional office accoutrements that are used in creating risk would be the best gauge. But I'm going to ask these guys a little bit later on if they think, well, I'll ask them now. Do you think, and because we got some feedback on this, do you think we should have included home-based workers and remote workers, because that's the trend? I mean, we see that, you know, big companies, some are pulling back on it. But what do you think? Should we have included the home workers or done it as we did it with the traditional office? Niloy, what do you think?
Well, I think that there's no logical difference between those two tranches of employees at the end of the day. Now, there might be some difference in, say, the volume of email usage for someone who's remote, but that doesn't change the fact that the risks that they create, for the most part, are going to be similar to the risks that people in an office space or a traditional brick and mortar setup would create. And I'm not sure that that traditional model is necessarily going to continue to apply. And I think particularly within the gig economy and some of the current generation of new business models, a lot of this work is being done remotely. In fact, while, yes, you're right, I'm a lawyer, I've done this for 11 years now. When I started, I was in a brick and mortar office, and for the last 6 years at least, I work remotely more than I do within an office. So by that definition, I would probably not
You're
qualify.
disqualified.
Right. Yep. So my opinions carry no weight because this data does not represent my experience. It does. So I think that almost all of us are to some extent remote, and I don't know whether your definition perhaps included people like myself simply because I'd be considered part of a brick and mortar thing. Sure, I'm associated with an office, but at the end of the day, I'm as remote as most other people might be.
Thanks. George, what do you think?
Well, happily, I am not included in any fashion in your survey results, so my personal behaviors are not reflected in any fashion here.
George is innocent. Let's just state that for the record.
But even if I were working out of a brick and mortar office, and I'll go ahead and take a leaf from the book you're going to turn to at some point. Here are some visual aids. It wouldn't matter whether I'm brick and mortar, because these aren't brick and mortar.
Excellent point. David?
All the thunder I had, and George just stole it.
Excellent.
These are my visual aids. I mean, I have David, the David person. I have David the Racker. I have separate laptops, separate phones, and yet I am an abject failure at separating my data. You know, the learned moderator and I go back several years.
I should have mentioned that when I was telling you about David's history. David and I were on the high school debate team together. Lawyers going way back.
And I'm coming here today to speak on a panel about separating employees' personal data from corporate data. And where does the learned moderator send most of the text messages about me appearing here? To the personal device. Where does he send the emails? To the corporate device.
Well, that just shows I'm incompetent.
My beautiful wife, to the corporate device, sends me all kinds of personal emails about what we should be doing this weekend.
And let the record show his wife is a lawyer who does employment work.
Yes.
I think it's only fair in the grand tradition of debate, which apparently three of us are subscribers to both amplify and cross-apply a couple of these arguments. There we go. Hey, debate humor. Yes, we are doing well.
Okay,
see?
this panel is going the wrong direction.
But first, some common ground. These two go back a long time because they're debaters. We're neighbors that never see each other except outside of our neighborhood. We literally live 3 blocks apart. So I know, amusing. Also, let me just thank you for using blue and orange as the colors on your slides. Because,
Go Gators, maybe?
Let's see. My undergrad, my law school, University of Virginia, and what I'm wearing today. So, you know, clearly we are very, very well coordinated, at least slides and myself. And notice George has done that.
I don't see any Cornell maroon on you.
No, well.
No, but he's wearing blue and orange.
I am being respectful of
I see, George.
But here's the point. I think the point that David Kilgore makes that's really critical. It's the same thing that I tell my kids about driving. You can be the safest driver on the road, and then you'll get in a crash, as my wife tells me every time she has a crash. and I think that is part of the problem. The reason you have to include the entire ecology is because it takes that one itinerant actor, one person who's doing something slightly differently that introduces risk. Now, I know we're focusing on emails, so I think it's worth pointing out that a lot of spoofing, phishing, and social engineering attempts, once they enter and infiltrate your network, everyone's data is at risk. So to a certain extent, it doesn't matter how careful you are. I think you've just demonstrated that. I'll just point out that I made my points without any devices, and I think that qualifies me a little bit more.
There you go. All right, my incompetence aside, 55% of the office workers surveyed thought that there was no harm, nothing wrong with sending personal data, personal information on employer equipment. 55% think there's no problem. George, what do you think? Problem?
Problems at various levels. And one problem from their perspective is that if they're sending and receiving, and we all end up doing this one way or another, personal information on corporate devices, their personal information at least has the potential of being swept up in a legal hold and then moved in through processing, put into a review platform, and who knows where it could go from there. So that actually isn't a direct problem for the corporation, but it's a direct risk for the employees, and one that they, in theory, could control by not using corporate devices for personal communications. But as we all know from our own personal experiences, and as we all know from dealing with data and electronic discovery, that's simply not how the world functions.
You know, and you hit a great point that I was going to bring up. LTN interviewed me about this research right after we did it. And the theme of the article turned out, this conversation, and thus the article, turned out to be you have to live in the world of reality. And we don't live in a perfect world. Employees are going to do things. David, the other counselor, Kilgore, and I are sending personal stuff to the wrong place. Frankly, I'm not even in the 55% that thinks it's okay. What do you think? Is Western civilization going to come to a crashing halt because we've got these employee data on employer devices?
No, it's not going to come to a screeching halt. It is what we have to deal with. It is where the world is. We will use the device of convenience, regardless of whether or not it is provided or sanctioned by our employer or we're doing personal things. That's just the functional reality. I am, in most ways, a Luddite of technology in that I make some visible effort to separate church and state, as it were. But I am the end of a trend, not the beginning.
Well put. The employment lawyer's perspective. Naloy.
Where to begin? So, going back to the original question of, is this 55% of people, are they correct or are they incorrect? I think the answer, as always, is it depends on two factors. One, what kind of information are you commingling? How concerned are you as the individual in that 55% about that information, and whether or not it being shared with others intentionally or accidentally would cause personal risk for you? But then on the other side, you've got the corporate risk, which of course is what we're more concerned about. We're more concerned from the employment lawyer corporate, and let me just be clear, Littler, 1,300 of us, all represent management. So we typically, or I will certainly come at it from that perspective of data leaking out from the organization. I think, though, that there's a larger point here about what the law has to say about all this. Because there's one thing for us to sort of blithely assume that logically we should be allowed to do this, because, as you said, that's the commonplace practice. And most of us would therefore see no harm in doing so. But the law has taken a pretty strict line on what the implications of this commingling are. And there are risks there both for employers and for employees. Obviously, employee risk is clear. if your information gets swept up in some sort of discovery request and it ends up getting reviewed. As I recall, as a young lawyer at Jones Day, seeing in front of me a CEO's entire multifarious affair life unfold because I was looking at every one of his female companions in his email, there is always that risk, right? But on the other hand, and I think about there's a case out of Southern District of New York called Pure Power Fitness that I think is probably the most exemplary of this issue. When you commingle data, there are two ways you do it, right? One is by actually having that text message that Mr. Horrigan sends to Mr. Kilgore. The other is by having on your device credentials, cookies, passwords, and access to your information. And those are two separate things. Because if there's a policy, and I know we'll come to one of those, to a slide about policies, but if there's a policy that says, as an individual, by using our technology, you're giving us a certain amount of possession, custody, or control over this information, and you enforce that policy, and the policy has teeth, you can use that as an employer to a large extent to control that information, to either make sure that you can get that information in discovery, and I'm not talking outside of the US I'm not talking about GDPR and the Commonwealth.
But shameless plug time, please stay in this room for the next session where we will be discussing the GDPR in copious detail.
Right. But also in the sense that, if you leave with that information, you've already agreed to return it to us. We can wipe the device remotely. We might be using mobile device management, et cetera. But here's the trap employers fall into, and this is what I caution my employers against. This is what Pure Power is all about. Put simply, small fitness company, one of the trainers leaves, employer, or the boss, she thinks that he's going to go start a competing fitness club and take her clients. Her assistant secretary office manager races into her office a week or two after this fellow's left and says, "You won't believe what I found. I found the evidence. That's exactly what he's going to do," and hands her a sheaf of emails printed out, all saying exactly that. Customer lists being stolen, emails, planning, collusion, the mother lode of evidence. And of course, the court says that the employer was at fault for having done that, because the way that information was gathered was this. The office manager turns the computer on, brings up an internet browser, and lo and behold, it logs into that departed employee's Hotmail. Right on top are all these emails. She goes, "Oh, it's on our computer." But it's not. It's somewhere in rack space. It's somewhere out there. Right. See how we bring this back? So there is.
We have a rebuttal from Rackspace
right.
on that one.
There is this.
We don't
risk.
host Hotmail.
Right. Fair enough. But it's somewhere in the cloud, and just because this device was a portal to it does not mean that you have your policy does not give you possession, custody, and control over, let's say, that email or someone's bank accounts if their passwords are, for heaven forbid, stored on their work computer. And that's the risk that employers deal with. When we're going into this multi-device situation, it's one thing to control what is resident on the device. It's another thing to know where you're running afoul of the Stored Communications Act, which is what happened here. And I'll end with this, Coda. If you think that's not real, twice in my career, I've had to give Fifth Amendment warnings to clients saying, you may need legal advice, you may need to plead the Fifth because what you're doing potentially incriminates you in criminal liability. And one of those times is not worth discussing. The other time was exactly this situation where a client turned on an employee's computer, Dropbox started syncing down all this information. And so I'm showing you exactly how slippery the slope is. When Dropbox syncs down to your computer, that information is now resident on that device. So you might say, it's on the device, I control it. But if it's after the employee's left, you should never have allowed that syncing to happen. As I walk into the room to talk strategy with this individual, I've just flown in from Minneapolis, he says, "Oh, Niloy, I'm glad you're here. I was about to show these people exactly what I did." And he was pushing the power button. I said, "Disconnect and pull the battery now," and I did it for him because that would have been right there. He would have once again violated the Stored Communications Act. And in fact, in that case, we ended up having to face an add-on charge and an amended complaint of hacking this person's Dropbox account simply by turning a computer on. So lots of risk on the employer side. Know how information is coming down and perhaps control what applications your employees are allowed to have, so that you don't end up in these quagmires.
And of course, you know, Naloy mentions the criminal ramifications, and you also mentioned international ramifications. If you were at the judicial panel on Monday, you heard Justice Vickery say that the unfortunate gentleman in Taylor Swift with his coffee on the MacBook and the mysteriously malfunctioning hard drive, that guy's going to the slammer. And so Naloy makes an important point here. He also touched on another point, policies by employers. These data were interesting as well. The majority of employees say their companies either don't have or they don't know if they have policies on electronic communication for checking your personal email accounts at work. 63%, almost 2/3, say there's either no email policy or they don't know about it as far as checking at work. Email retention, once again, you're looking at almost 2/3. And this one in 2017 is kind of disturbing. Over half of them say their companies either don't have a social media policy or if they do, they don't know about it. Let's start with Mr. Kilgore on this one, about these employer policies.
It's good to know I'm in the majority.
Ah, okay.
As an employee, I am in the majority of all of these.
If you can't say, feel free to say you don't want to respond. Where do you fall? Where do your companies fall in this? Let's start with social media. To your knowledge, do your companies have a social media policy? We have a pretty sophisticated electronic community here.
It's e-discovery.
Yeah, that's exactly,
Yeah.
exactly.
Here's a question, Tom.
Yeah.
When checking personal email, that, I don't know the studies, but was that focused on employer devices or on?
Yes.
everyone?
Yes.
Okay.
But the interesting thing about this is, you know, taking the first one there on email, no, excuse me, the middle one, the retention.
Retention, sure.
Yeah, we don't have a specific email retention policy. We do have a document retention policy. And you know, whether a particular email qualifies as a document is a question for an entirely different conference.
Sure.
But,
Right.
That's how we deal with it.
yeah.
Or what's the definition of a device, corporate owned or otherwise? That's a
another
whole other
issue.
discussion.
Yeah.
Yeah.
That's,
Yeah.
you do that.
But as,
And then is it a black and white distinction? You are never supposed to do this, or under certain circumstances you're permitted to do this?
If you're a CEO.
And again,
Yeah.
look at pure power, because the court goes through this hair-splitting exercise and says, well, you might have a policy. Was it enforced? Is the device public use or truly personal use? In fact, the court even says, was the device used at a cubicle or in an office where you could shut the door? All of these to try and figure out how much privacy should be imputed to that activity by this employee. And of course, in that case, the computer was at the front desk of this fitness place, and still, you know, eventually the court said, yeah, you shouldn't have looked in this guy's email. But that's a hair-splitting exercise. It's far better to have a policy that says, do this, and we control or agree not to do it.
Do all three of you agree that it is worse to have a policy and not enforce it than not to have any at all? George?
It is much more challenging if you have a policy and don't enforce it. It's even more challenging if you have a rigid policy and choose not to enforce it. But I'm going to slip to a couple of questions you didn't ask. This is asking employees.
Right.
What about people who, in their official capacity, ought to know the answers to these questions? I wonder how many of those people would think they knew the answers but wouldn't. And I ask that question because that really presents an opportunity in one way or another for probably everyone in this room. Because in one way or another, we're all sitting on client data that we are using for a variety of reasons, legitimate, we hope, always,
Yeah.
but which can be used in yet another way if the client deems it appropriate, which is to use that data to test whether corporations are in fact complying with whatever policies they have in place. So do you have a policy? Do you think you follow the policy? And then do you in actuality follow the policy? And the best place for that latter to figure that out is not to ask people, but to look at data.
Naloy, I'm sure that, oh, Courtney, go ahead.
Question about people. How is anonymized was this? Were you able to actually go to the companies that the employees represented and say, do you have a policy?
No, we didn't do that.
Okay, that would be, it would be interesting to get that
You know, you're right. It would be interesting to have that. Next time we do it, that's something to consider. That's a great point. Naloy, I am sure that you get the proverbial question, gee, how long should I keep my email? Probably not in this crowd because they know it's the old lawyerly answer, it depends. But what is the challenge of putting together an email policy when you're dealing with disparate organizations, I should say, in different industries, different regulators? How do you crack that nut? I mean, you can't have a boilerplate template for all. I mean, are you going to go through and try to find any potential regulatory coverage, or how do you go about advising clients on retention policies?
Well, typically what I do is I say, we have a records retention group, and they have decided to take on this decidedly onerous task of helping you figure this out. And also we know some great consultants and technologists who will certainly help you implement this and figure out the nuances. But I think that hits the point on the head. As an employment lawyer who works for employers and does e-discovery, I don't feel qualified enough to answer that question. And the reason I don't feel qualified enough is there are 3 reasons you retain information. And 2 of those are completely outside of in fact, 2.5 of those are outside of any lawyer's ken, frankly. One is because you need it for compliance and regulatory purposes. And for that, you have to look to your compliance regulatory officers within the organization. They and only they will know enough about your information to know what different laws you need to be meeting. You know, whether it's HIPAA, FCPA, SEC regulations, DOJ or FTC guidance that you have to deal with.
OSHA is incredible on this.
I haven't, I was going to get to OSHA, but
Oh, sorry.
hold the OSHA just for
Okay.
1 second, because I think it really applies in a way that equalizes us all and normalizes this whole, or should normalize this conversation. But setting OSHA aside for a second, those are things that only the organization will know, and sort of like Sedona Principle 6, the organization is in the best place to know what regulations it needs to comply with, and therefore what retention they need to follow. And that's one reason. That's probably the most important reason to preserve information, because there'll be liability, legal or otherwise.
But
if you
Naloy,
don't.
do you think that the guy on the line in an oil refinery has any idea?
Right, but neither do I. I feel as though
Okay.
in these industries, he and I or she and I are in the same boat.
Okay.
Now the second reason, and here's where the guy on the line or the person on the line is better off than I am. And that's the second reason you need to preserve information, and that is for operational reasons.
Sure.
I can't tell you, you should probably hold on to these emails for 6 months. You ain't gonna need them beyond 6 months. No. That person on the line will say, no, I need to go back 13 months out from my contract to make sure all the terms are met, then I can release this. So that's the second reason. I have no knowledge of that. Excuse me, I think Relativity is telling me that something important is happening. It's not this, apparently. The third reason you need to preserve information is the one where I come in, and that's for litigation hold purposes, right? And so there, I have a small window. I know the litigations that we're handling for you, and for some companies, we may be handling, upwards of 800 or 900 lawsuits, and we know, okay, everything's under hold. But that, again, the legal department is going to have the best information. So typically what I tell clients is these are your 3 buckets of needs to preserve things, and they are in a hierarchical order. Everything you need to preserve for compliance needs to be determined first. Then if there's something you're missing operationally, that comes second. And why that comes second is if you go the other way, you say operationally, we don't need something, then you might be running the risk of regulatory noncompliance. So you do the compliance piece first, then see if there's something operationally you need to hold on to. And then this is probably the most important thing after that. If there's something left on the table that you don't need to preserve for any of those first 2 reasons and is not already on hold for pending litigation or anticipated litigation, get rid of it. Do whatever you can. Do the 2-step. The 2-step is something that we've used, and OSHA comes to mind for this. The 2-step is one where you take information that's reasonably accessible and make it not reasonably accessible. And I mean that both in a technical and practical sense. Put it in an archive where you assure your employees, you can get to it, you just have to go through 1 extra step to get to it. And then when a month, a year, 2 years go by and no one has touched those archives, then you can go back and say, do you feel comfortable without those training wheels on your bicycle? You do, right? We're just gonna go ahead and throw the training wheels away. And that's when you start jettisoning this stuff. And if you can get on that path, for most organizations, because you have so much data, you can start trimming the head of the funnel. And much as I'm an e-discovery lawyer, I don't like email. I don't like when companies come to me and say, oh, we've got everything in the world preserved. I go, boy, that's going to be a lot to review. Whereas if I tell you, you know, that lawsuit happened and our preservation obligation has been triggered, but 2 weeks ago, before that was triggered, and this true story, Hurricane Sandy came through and some of our servers ended up in the Atlantic. And I went, oh, heavens, Lord be praised. And they went, what? I went, no.
Let the record show, not reasonably
terrible,
accessible.
Terrible for you, but oh, good job. Well done. And who drove it out to the beach? Give that man a raise. OSHA comes to mind, though, because you're right. OSHA has interminable regulations. And one of the things,
long retention periods.
and what have we done in the business place, in the workplace, to address that? Every time you go to a restaurant, right, you see that little sticker in the restroom if you happen to go, and you're not a germaphobe, and says, employees must wash their hands before they go back to work, and so on and so forth. You see these employment-related posters, stickers, warnings, and advisories plastered over most workplaces, other than, say, the corporate workplaces.
Yeah.
And I think that what this tells you is that maybe stickers like that need to go up in people's offices and cubicles saying, be aware, these are our policies.
As a former products liability lawyer who dealt extensively in issues having to do with failure to warn, one of the things I learned is that the more warnings you put out, the less attention anyone pays to any of the warnings you put out.
Boy who
That
cried
may be
wolf
true,
is
but
an
it gives me
important point.
defensible, it gives me plausible deniability as to
Well,
failure to try to do so.
It gives you deniability. Whether the deniability is plausible, however, is another
Is a
question.
matter of fact, yes.
All right, now we are going to delve into the scary world of wireless. And it's absolutely scary. At Relativity, for instance, I have a separate phone for Relativity. I've got a separate personal phone. And our head of security, Bill, has told me I have his permission to run the hotspot secured on my iPhone, my Relativity iPhone, anywhere I go, airports, hotels, whatever. I've not had this conversation with finance as the data overage charges skyrocket from running this device, but it hits a point home in that you've still got to run your business. And it's the operational point that Naloy made on this, and that's why sometimes the guys in the trenches on this. And I have a strong feeling that Relativity Finance probably has a much different take on this than Security Bill does. At the end of the day, I think I'll go with Security Bill on this one. But as we go to wireless, I may be exposing myself as a dishonest person, because when we were setting up these questions, what I wanted to go to Harris was and say, I want to know a cumulative number of what percentage of the people do one of these potentially naughty behaviors. And so when I wrote up the article that we ran on the Relativity blog, and I think they published it somewhere else as well, Law 360, that's right. Shout out to Law 360 for publishing the article. Harris came back and bounced it, because any good journalist will tell you they're not going to let Harris Poll dictate what they write. However, Harris Poll can tell Horrigan the lawyer that he has to be completely honest in how he presents the data. So what Harris Poll made us do is insert all these numbers for each habit here, rather than having Horrigan say, look, over 60% of the people have done these bad things. So let's go down the list. This is what people have done over company Wi-Fi on their personal devices. Almost half have sent personal emails. Once again, close
David,
to half.
I'd like to interject a question.
Sure.
Why does on-company Wi-Fi matter here?
The idea is that you are putting data on the company Wi-Fi that is potentially unsecured and potentially accessible.
But I'm doing it on the company's Wi-Fi, which is, if security, you've got a security bill, I've got a security mic, that, you know, if things are going well, if they are doing their jobs, then that is a secured network.
Not always. I mean, obviously, you're an expert on this, but many companies' security on their wireless networks leave a lot to be desired.
And so because you don't know which they're using, secured or unsecured, how do you evaluate the results of this question? But a
Touche.
separate question. Why do you believe the results of this, the answers to this question? I think the answers are 100% down the line.
No.
Aha.
I,
We have a rebuttal here, Courtney.
well,
Yeah.
if my personal device pops up for my work Wi-Fi, I say no. I will continue using the data on my
99.9999%.
See, the techie, the techie people will say I'm being foolhardy here, but I often will charge my personal iPhone off that Relativity laptop there. Now, I always say do not trust the device, but the techies will tell you that there's still little bits of datum that are being transferred between that iPhone. Fortunately, I'm not involved in Al-Qaeda or ISIS or anything else, but nevertheless, I realize that that is risky. I'm thinking I'm mitigating my risk by saying don't trust this device. But I'm well aware that it's not foolproof.
But I do go back to David's question of why company Wi-Fi in this question?
Yeah, in my opinion, it's the behaviors that are the risk, not whether you do it on the company Wi-Fi or not.
True, both are true. Company Wi-Fi was inserted in here because I am a high-ranking member of company. Let's not use something as gross as Al-Qaeda. Let's say I am running porn with animals. Not that that's any less pleasant, but
This hole is getting deeper,
sorry,
David. I
is
suggest
that-
putting the shovel
All
down.
right.
Was that an
Let's
Alex
just say- all right.
Kaczynski reference?
Trump, all right.
When in doubt.
I think go with the counterfeit handbags as your safest course right now.
All right, now we all know that Ivana the mom had to redact her book before the Donald would let her publish it. So I have the redacted pages of Ivana's book. And I'm putting it on the company Wi-Fi. I'm an executive at that company. I'm a senior person with the company. I don't discount the point you guys are making. It's a good point. I'm just giving you the rationale that went on it.
And so if you plugged in the Ethernet cable and did this, would that be better or worse?
Very good.
The company internet is better.
Yeah.
Right. Well, the idea with
Company
an Ethernet
network.
is it's less on an Ethernet. It's less likely to fall into nefarious hands outside the organization. Would you agree?
No.
Oh.
I mean, technologically, nothing's secure.
Right.
And you're not
Yeah.
going to have sniffers inside your building, hopefully. Hopefully, building has security, and your Wi-Fi radius is not going to be more than 5 or 10 feet outside of your building. And if it is, that's concerning. Maybe dial it down a notch. But I think the point, the key point here, let's not get caught up in the company Wi-Fi thing. The key point is these numbers are underrepresented. People lie. I'm an employment lawyer. Let me tell you this, people lie.
There's the latest quote for the Best of Relativity Fest. People lie.
Right.
And when you are an anonymous respondent to a survey, that doesn't mean you tell the truth more.
You believe the best version of yourself. But look, this is so difficult because I think that you're saying personal devices, right?
Right.
What about if you posted these over your company device? Would that make a difference? No. And my company, my partnership requires me to use social media. Requires me to use social media. I have one social media account. It's LinkedIn. I don't do Facebook. I'm an e-discovery lawyer. I'm terrified of those things. But I have to post on social media. So they require me to do it. And so they...
And by the way, you should go back and tell your people they're great at social media. For instance, I tweeted this session this morning. I put the Littler hashtag on there, the Littler handle rather. They had it retweeted within moments. And that's a common place with Littler. So I think they're doing good work there.
Thank you. Yes, we have technologists working on that as we speak. But that's it's just, I guess what, my question is, why does this matter to you, David? Why is this a bad thing? Is it just the security aspect of it?
It's the security is one thing, but it opens up a potential Pandora's box of bad, naughty stuff that we don't want on the company system.
So infiltrating into the system.
Right. On our next one.
Well, before
Go,
we get
before
to
we
the
go.
next one, I think the challenge you face, though, is that I suspect my experience has been similar to that of others in this room in terms of what I have observed about organizational behavior and the behavior of employees within organizations. They are going to use the tools that allow them to do what they think they need to do for their jobs. And often that means they end up using personal tools for work purposes because they feel that's going to let them do their work more effectively. And that puts them right into these numbers.
Sure.
Then there are the people who are told it's okay to use work devices for personal purposes up to a point.
Sure.
And that point will vary. And so for those people, what they're doing here is assuming it's where it's supposed to be appropriate. But we get back to the question, and back to my earlier suggestion, we don't really know often what the practices are, and a useful exercise can be to take a look within your own organization or suggest to clients that they have you help them take a look within their organization to see what's really going on, whether people's behaviors actually are comporting with the policies. If they're not, then do you want to try to modify people's behavior? Do you want to try to modify the policy, or probably a combination of the both?
Sure.
But look to see what's actually happening.
Yeah.
And that can tell you much more about what to do than these tantalizing, generalized survey results.
I would assume you have more control of the outcome to modifying policy than behavior.
I think so.
The next collection of data, not a whole lot surprised me here. I thought some of the numbers might be higher or lower. Not a whole lot surprised me, except for this one. Whoops, going in the wrong direction now. It's continuing to go in the wrong direction. Here we are. Employees who use work devices for conversations that should be confidential. What surprised me is that physicians were almost double lawyers. Show of hands, have you ever had a conversation, especially an electronic conversation, with your physician on a company device? And the reason I ask this question is, I've never known doctors to use email. Sure, electronic records for medical records, but these guys don't communicate on, and women don't communicate on email. Have any of you ever communicated with a doctor on your company device? Or
Well-
really?
Yeah, well, it's my own device, but I have
Yeah.
email, but yeah, I text my doctor all the time.
And she texts back?
We don't really go into details, but yeah, she's extremely responsive.
And
Wow.
Regular text, not knocked down.
No, we don't go into detail. but
Sure.
Yeah.
Well, shows you what I know.
And we too, yeah.
portal systems, or was it targeted specifically to email or text?
Any company device.
Because a lot of, yeah.
Manner of conversation is what the others
And in fact, we shouldn't have used conversation here because it didn't include the telephone. That's the one thing it didn't include, and that's poor slide development on my part.
Here, there are more people have doctors than lawyers.
Yeah.
Well, that's a good point. And it just is, I have communicated with my personal lawyer on my personal email all the time. I just have never known doctors to do that. In fact, they don't invite you, they don't give you their email addresses.
Oh, David, you need new doctors.
Apparently I do. Those Luddite doctors I go to. Naloy, your client emails you from his work email. What are you going to tell him?
To my work email?
From his work email to your work email.
I don't see a problem with that. And I don't see a problem with that because A, it's privileged, B, no one's ever going to come discover my email. And if his email is, heaven forbid, collected. Remember, most of my clients are going to be either legal or legal affiliated, so I'm not too concerned.
Yeah, you're a bad example. All right.
About that.
Okay.
Pick
Well,
me,
well,
pick
here's-
me.
David, okay, yes, please.
And I will say I am guilty of 2/3 of those items up there right now.
Okay.
I am the executor of my father's estate. I am dealing with financial people and lawyer people during business hours, and I leave home at home and I do work at work. So yes, I am guilty of having privileged conversations with my lawyers on the company email. I am guilty of having conversations with financial advisors on company email through, in their case, mostly secured messaging portals on their systems. But it goes back to the habit of using the device of convenience. You know, if I'm going to communicate with these people during business hours, then the highest probability is either A, I'm going to bring a personal device, put it on the corporate Wi-Fi so that I can get to the internet, so that I can exchange messages, so I'm guilty over there.
Well, let me ask this question of the audience. How many of you believe that if you exchange email with your lawyer over your work device, work email, like the situation you were pointing out, that exchange of communication isn't privileged? You believe it isn't privileged. Everyone else believes it is privileged.
I'm with Courtney. And here's the scenario.
Go ahead.
Once again, you guys, I think, have more faith in corporate networks than I do. For instance, if I'm ever in Manhattan in a hotel or an office building, I pull out the laptop and I must have 36 wireless networks sitting there. I'd venture to say, now granted, many of them may not be corporate, I don't know what they are, but huge percentages of them, even in 2017, are not secured. But in this case, the data get out. Is the court going to say that you and your client have taken reasonable precautions to preserve the privilege, or are they going to say you waived it through carelessness?
Right, but it's. I agree. That's a separate step. That's whether or not someone grabs the data. But I'm with Courtney on this. Most people have an expectation that per se you've had this communication, therefore the communication, so an employee, remember I represent the employer, employee uses their work account to communicate with their lawyer about this very lawsuit that they're now filing against us. And they believe that that must be privileged. Courtney, clearly in the minority, believes that that isn't privileged because it's over a work network or work system on a work device, present on that device, and therefore, we should have full access to it as the employer. The sad truth is that while you are technically mostly going to be generally correct, if I say so myself, so let me qualify that as much as I can, it's not worth the fight. So what we do prophylactically,
Which fight is not worth
the fight of justifying that it was all right for us as employers to look at that communication because
The other part of that,
Yeah.
though, is when you're talking privilege or what an employee considers to be privileged, that isn't about the lawsuit at hand. It's about something else. It's about the estate planning or the.
right, but then we don't care about that because then it's outside of Rule 26 and I'm not looking at it.
Well, Niloy, I'm sorry, Courtney, go
But there's a
ahead.
cost to not looking at it.
It may be produced, it's out there.
Right,
Yeah.
it may be. But I think what happens is, what I'm saying is that at the law firm, the advice we give is prophylactic in nature, which is to say, if ever, and we do this routinely in lawsuits, you'll get an employee's email account, or you'll get their device and you'll extract some manner of data from it. We always run privilege screens, not for our privilege stuff, but for their privilege stuff. And when we construct forensic protocols, or when we construct any of those things where, say, George or someone else is going to come in and help us with this, one of the things we bake right in there is, listen, as soon as we see privileged information between you and your attorney, which we may know exists because we've done keyword searches without looking at the results, we're not going to look at that anymore. We're going to give it to you, and you get to log it, and you get to give it back to us. So I think it's a gray area in that it's not worth the fight to try and prove by holding up various cases. And courts are conflicted on this. And courts make bad decisions from time to time, where they make decisions where they go with a policy as opposed to an established, maybe persuasive opinion from somewhere else, where they go, back to David's point, employees probably expected that they were able to do this. You weren't enforcing this. You weren't going around putting stickers in cubicles saying, don't do this, George. And so, and so having, involved both of them in this dialogue, what I say is, it's sometimes better to prevent than to have to deal with it. The answer is gray. There is not a Supreme Court case that has come down, or a majority of circuit courts that have said, yes, any communication that is resident at the time you're an employee is definitively, not privileged. So I think you're in the right, but I think you're in the minority because of the expectation of logic versus law.
Let me join forces with Counselor Murphy here. Say we get over Horrigan's paranoia of corporate networks, and we're going to say the network's perfectly secure. I think our best argument is Perenboom v. Marvel Comics. That's the case where, this is a nasty case, it's worse than unfortunate references I may have made to animals in photography. This case, it's all over an expletive-deleted condo dispute between the CEO of Marvel Comics and someone else in his condo complex. It got nasty. There were accusations back and forth of activities that I'm not going to mention here. I've learned my lesson. Let's just say it was bad stuff. It's nasty. The CEO of Marvel Comics is communicating with his lawyers about this case on the company email. And lo and behold, the other side like, hey, we want that, you waived the privilege. He's like, no, I don't. New York court rules in favor and says the privilege has been waived partially because he was communicating on the corporate network. Marvel Comics had a policy that anything on our system is ours. Thus, he's the CEO. He should know his own policies. Granted, I know the fact pattern in the law is unusual. The CEO has a policy, doesn't follow it. Maybe it's not that unusual. But
He's being held up as an example. Let's be clear. The fact that this individual was the CEO and the judge didn't like Marvel's movies, was a DC Universe fan, may have played into the decision.
But is Perrin-Boom, the Marvel Comics case, is that too much of an outlier, just a weird fact pattern, or do you think it's a legitimate concern?
No, it's the fact that it exists makes it a legitimate
There you go,
concern.
very good.
But it is an outlier, and you have cases on the other side where we have had to deal with judges saying the exact opposite. This person reasonably, this store manager, when they were sending pornography over your system, because they were engaging in it through Hotmail, even though you may have seen it, you can't use that as after acquired evidence of a reason that you would have fired them anyway. You would never have known if you hadn't infringed their right to privacy. So it's a legitimate concern. Another legitimate concern along those same lines, switching to Sony from Marvel,
a good one.
would be when your data get compromised. So bringing it back to what David's original, I think, very good point is if you have this out there, and I said this earlier as well, how concerned are you if it gets out into the public sphere, despite your best intentions and how well you and your company are driving? The Sony hack happens. A lot of emails, as you know, flood the internet. And one of the consultants that we work with, not George, because I'm about to say something scary, and I don't want you to think it's George, but one of the consultants we work with is a white hat hacker. So he says he may still be a black hat hacker, he may still be doing things nefarious, but we don't know this. He's a white hat hacker, and he keeps coming to me and saying things like, hey, you know that person we were investigating? We're investigating people to see, what their digital lives are. So is it okay for me to spoof or socially engineer and get access to their accounts? And every time we say no. So he's learned that lesson. You can't go pretending to be someone else. Then he says, I've got a twist for you. I can find this person's email. It's available on the internet. Is it okay if I get it for you? And I said, how come his email is available on the internet? Well, there's this Russian Tor onion site that has a lot of compromised data. Wait, no, you can't do that. So finally he comes to me and says,
Obviously he can do it.
well, right. You cannot, for me, legitimately perform that service under the terms of our contract. So you cannot do that. So then he says, the Sony hack that happened, could I share some of that data with you? And I was so tempted. They make a lot of great movies. I want to know what happens next. But that is a concern, right? Sure. Because once it's out there, I don't know that there's actually been a federal lawsuit on that issue. There have been some state court decisions where people have acquired this email. There have been like marital disputes and contract disputes and condo disputes and things of that nature. There hasn't been a federal court case that I'm aware of where the court said, yes, now that it's out because of a hack, it's not fruit of the poison tree. You can go get that. And I do think that's something to be concerned about. Equifax just got hacked. I mean, your private data, your security is not as secure as you might think it is. So think twice before you put it on that device. Think twice before you have the same password for every single account that you have, because the leaks are multifarious, and one leak is all it takes.
Sure.
As our security people tell us, it's not an if, it's a when.
There you go.
There was. Can we talk about corporate policies as far as what happens if you leave your system open?
I'm happy to, yes.
Okay. At Relativity,
Compare our notes.
if you're caught with your system open, you get a sticky note from Security Bill that says, what could possibly go wrong? And then you are compelled to purchase donuts the following Friday for your team. So the incentive is not to have to go and buy donuts on Friday morning.
Well, aren't you sending mixed messages?
Well,
that
of
way
course
for the
we
people
are,
who want
George.
donuts on Friday
We're trying to
morning?
make security fun. Mr. Kilgore, from what I've heard from you at the bar, I have a feeling things are a bit more draconian at Rackspace.
So much for bar privilege, huh?
Well, that's why I asked you ahead of time. You could have talked about some company
You
in
didn't
Minnesota.
tell me which conversation.
Okay, we don't have to talk about that. We don't have to talk about that.
No, and we have our security Mike, and he will come by, and if he finds an unsecured laptop, he does leave a Post-it note. in the dock where the laptop used to be, as he takes the laptop to the security office, and the note says, "You and your manager need to come by and see me." It's particularly inconvenient when your manager is the CEO.
How often does that happen?
It has happened.
Fair enough.
Before we get on to, well, I'm going to ask you something. Before we get on to closing comments, last questions. And
No, I was just gonna say those are very like an applied discovery, which is where I first worked. You got one warning and then you got fired.
are you serious?
It was pretty bad. Some people, they made an exception. I feel like, but it was pretty like maybe you got more than one, but you could get fired for that.
No, there is the donut thing, and we try to make it light and just remind people.
This is not Lexis
But
this is applied before. It was
Before
actually
applied.
because
Right.
at that point I was on the project management side, so it's not the sales team, right? These are the actual people who manage the data for clients. So it was extremely
Sure.
like everybody had
yeah, and this is not. There's hardly any confidential data on these systems.
yeah, no, it's
They-
like sales.
Yeah.
They just have the people who are buying the services. You don't really have the data, but
I can assure you, in the ISO 27001 certified relativity data holdings, it's a little bit more than buying donuts.
And I will say I am unfamiliar with the content of any of those conversations once you're manager and you get down to the security office.
Right. Any other questions before we go to closing comments? All right. Final word from David Kilgore.
And in the overall topic, it's going to happen. You have to figure out how to live with it.
From Noloy Ray.
Inspect your contracts. All of your contractors might be subcontracting, and you don't know what the security measures are that those subcontractors have in place. The easiest leak is the hardest to find sometimes, so be sure that your service agreements are as ironclad as your internal policies, because once data leaves your four walls, security may be at risk.
And the last word from George Sosha.
Inspect your content.
Ah,
I mean, you may have policies, you may think you have practices, but until you inspect your content, you don't know what those practices actually are.
on behalf of the over 800 Relativity employees around the globe, our partners, our developer partners, and of course, David Kilgore, Noloy Ray, and George Sosha, thanks so much for getting up early this morning. I know you probably would have rather laid in bed after a party, but we thank you for being here. It's been fun. Thanks, guys.
Thanks to you.